Welcome to Planet Lex, the podcast of Northwestern Pritzker School of Law, with your host, Dean Daniel B. Rodriguez, bringing it to you from Chicago, Illinois. Take it away, Dan.
Hello, and welcome to Northwestern Law's Planet Lex, podcasting from the Northwestern Pritzker School of Law here in Chicago, Illinois. My name is Dan Rodriguez. I'm your host. Joining me today to talk about issues of technology, privacy, and the law is my colleague, Jim Speta. Jim has been a member of the Northwestern Law faculty since 1999. His research interests include telecommunications law and internet policy, antitrust, administrative law, and market organization. He previously clerked for Judge Harry Edwards on the United States Court of Appeals for the D.C. Circuit and practiced appellate telecom and antitrust law with the Chicago law firm of Sidley Austin. Or maybe it was Sidley and Austin when you were there.
That's exactly right.
Took away the ampersand. So Jim, thank you for joining me.
Great to be here.
So no big secret, what's on folks' minds, certainly those who are in the telecom world, is the fate of net neutrality. As we were here meeting on March 28th, I am looking at a blog post from earlier this morning entitled, "You Have Just Hours to Stop Congress from Giving Away Your Web Browsing History. Time to make some calls." What's that about?
Just at the end of the Obama administration, the FCC adopted rules that would forbid internet service providers from collecting and using customer information such as where are you browsing, how long are you there, what services are you using, without a very explicit consumer opt-in. This legislation will rescind those rules and forbid the FCC from making any similar rules in the future.
And what is the status of the legislation, again, as we're here near the end of March?
It's already passed the Senate, basically on a party line vote of 50 to 48, and it's pending in front of the House. It's expected to pass, and President Trump is expected to sign it.
What is the concern? What is the worry that underlies? First, let's start with the regulations themselves. What is the boogeyman here?
The worry is that the internet service provider to whom an individual connects is in a position to capture an extraordinary amount of personal information just based on what you're doing on the internet. And today, of course, people do everything on the internet. So the FCC's rules were designed to protect individuals' privacy in their web use, essentially.
So when you mentioned a moment ago that under the current regulations, there's an opt-in provision. So it sort of puts the onus on the providers to have to request consumers to opt in. How many would opt out? I guess it's just another way of asking the question is, what is the real threat to individuals' privacy?
That's a very contested issue, although it's usually contested at the level of whether people care about their privacy. We have some data from other types of services that when people are given very explicit information about how their personal information is being used, they do opt out in more significant numbers, but they tend to opt out in the range of 20 to 40%, 50%, depending on the kind of information, not in the range of 80 or 90 or 100%.
If Congress is successful, as it appears it would be, in enacting this repeal and then actually enacting this overturning of the FCC regs and the president signs it, is it still available to the Federal Communications Commission to adopt modified regulations? Would that be permissible under the relevant statutes?
The relevant statute, and you and I share this sort of interest in this quirk of administrative law, is called the Congressional Review Act, which gives Congress 60 days to pass a law overruling any regulation. That law says that the agency cannot then adopt a substantially similar regulation, and the issue then would be, is any modified rule substantially similar? I think the intent of Congress, in passing this repealer, is to try to get the Federal Communications Commission out of the business of regulating internet privacy in preference to the Federal Trade Commission.
Interesting. So that brings us, since we're talking about the FCC, back to the new chair, Mr. Ajit Pai, who was appointed by the Trump administration recently to head the FCC. I see here he's advertised at the time of the inauguration as a net neutrality foe. It says net neutrality foe to head the FCC. So in getting us to talk about the new chairperson, I guess I first want your précis on what this business of net neutrality is about.
The essence of net neutrality is the question of whether there ought to be regulations on your access provider, your Comcast or your AT&T, the company from whom you get your internet access, regulations that forbid that company from discriminating among different content providers or application providers. And in 2015, after basically 10 years of trying to do so, the FCC adopted some rules forbidding that discrimination that the D.C. Circuit upheld just last year.
So let me just underscore the 2015, because there's a sense when one reads some of the popular literature on net neutrality, it's sort of a state of nature in some sense, or it's always been around, or it's part of the underlying philosophy of communications law or the internet. But that's not the case at all, right? As you mentioned, it's really been more or less a couple of years since the relevant regulatory authorities have put a stake in the ground and said net neutrality is part and parcel of how we should think about regulating the internet.
That's true. And the issue of net neutrality is tied to an underlying, much more important issue of regulatory classification. To go back to the sort of premise of communications law, there has been a non-discrimination obligation in communications law since the beginning of communications law, since 1934. But what was different was when the internet came into being, say in the mid-1990s, when it became a commercially and much more popularly available service, was that the FCC said, we're going to leave our hands off the internet, and we're not going to treat it as the same kind of service as traditional telephone service, not going to treat it as what we call a common carrier service. Now, when the internet became in the mid-2000s, 2005, 2006, the dominant form of personal communication, the FCC began to reconsider that issue and to say maybe we need to think about some controls over how internet carriers can behave. And starting in 2005, the FCC adopted some principles and some policies suggesting what they wanted was a non-discrimination rule for internet carriers as well. And it went back and forth to the D.C. Circuit twice and failed. The D.C. Circuit was not convinced that the FCC had authority to impose these rules without also calling internet service a common carrier service. So in 2015, the big step that the FCC took, and it's an enormous step, was to say broadband internet access service is common carrier service, and we are going to impose many of the same rules that have always applied to telephone companies to internet carriers.
Tell us a little bit about the FCC in this context. I mean, I noticed you didn't mention the C word, that is Congress, in this discussion. They enacted the Telecommunications Act in the mid-1990s, but it sounds like despite the drama over how to think about regulating or not regulating the internet, this was mostly actions on the part of the relevant regulatory commission and not big bad Congress.
It was mostly actions on the part of the Federal Communications Commission. Congress considered bills, couldn't get them passed. Many representatives and senators expressed their views to the FCC at one point in, say, around 2010. More than 200 members of Congress wrote to the FCC saying, don't do net neutrality regulation. And so it was a politically contested issue. It was an issue on which President Obama weighed in. And during the entire time of President Obama's FCC, there were 3 Democratic appointees and 2 Republican appointees, and this issue split the commission 3-2. One of the reasons we know that the new chairman, Chairman Pai, is so opposed to net neutrality regulation is that he dissented from the 2015 order.
So his appointment came as no surprise to anyone with the election of Donald Trump. I'm curious, was this an issue that was prominent at all in the presidential election? Was this an issue about which Trump or the other Republicans ran?
No, it was mentioned, and it was mentioned in the Republican platform, but it didn't have any salience, as far as I could tell, in the political campaign in 2016. It had a little bit of salience in 2012, and President Obama, as I said, did mention it a few times and was clearly personally in favor of net neutrality regulation.
Does the chairman have the power? He obviously doesn't have the unilateral power, but just from the political wins, does he have the power to make good on his promise to eradicate the open internet order?
He probably does. He probably has to wait for appointment of a full FCC. And because we're outside this sort of funny 60-day window that's being used in the broadband privacy order, the FCC would have to go through a new rulemaking proceeding, which, as we know, notice and comment and a whole bunch of other public procedures before it repealed. But the Republicans will have 3 votes, and the Democratic appointees will have 2 votes because we have a Republican president.
Right. And whereas if the Senate were under Democratic control, there could be a real likelihood, right, that there would be confirmation wars. It doesn't appear likely. If the Senate's vote on the broadband privacy rules, right, which was 50-48, as you described, exactly on party lines, is any indication, that would be probably identical to the vote on confirmation of FCC commissioners, correct?
I think that's exactly right.
Let me ask a different question, which is sort of the what's the big deal question with respect to the repeal of the Open Internet Order, at least based on what I read. And this falls under the rubric of a little knowledge is a dangerous thing, but I'm sure you'll correct me. And that is, the net neutrality rules only apply, as I understand it, to what is called the Internet backbone, right? So the sort of the basic structure of the Internet. Now we know that a lot of the utilization by consumers of information that comes through streaming of Netflix and others, or through these big companies, AT&T, Comcast, Verizon, and the like. My understanding is most of that activity, which is a significant part of the activity of the consumer use, again, streaming of Netflix videos, for example, is outside of the Internet backbone, as it were, right? So the questions of discrimination in terms of fast speed for these particular companies isn't covered in any event under principles of net neutrality, or is that incorrect?
No, you're exactly right that there were significant gaps in the FCC's net neutrality order that therefore the order didn't go all of the way towards a non-discrimination requirement. Some of those have to do with what you've mentioned, the way the backbones interconnect with the local access networks. Some of them have to do with classifying what services were subject to a non-discrimination obligation. So the rule tried to eliminate discrimination between different kinds of services, but if the access network decided to offer the service itself, it just wasn't subject to the rule. The important part of the rule was this reclassification. To call internet access a common carrier service then gave the FCC the power to go those additional steps. If they felt interconnection was a problem, or if they felt classification of types of services was a problem, they were clearly going to be able to regulate it. And they put a stake in the ground that said, what we want is an open internet, a non-discriminatory internet.
So this dwells in the realm of speculation, I suppose, had the election come out the other way. Actually, not true. So let me say this. Suppose there's a change in administration, and in the coming 2 years, coming 4 years, there's a greater emphasis on revisiting the matter of net neutrality. Of course, technology will have changed somewhat by that time. Do you anticipate, and could you anticipate, that the FCC, in tandem with the new administration, will revisit the question of how broad to expand the scope of regulation? I guess a less cumbersome way of asking the question is it possible that these streaming services and things outside the scope of the internet backbone and these very big and growing companies like Verizon, Comcast, others will be subject to greater regulation and greater control?
Yes, and one of the concerns of industry and of consumer groups is that we could see a lot of back and forth about what the scope of the regulation is, even on these fundamental questions of common carrier classification. I think, my sense is if we had a new administration, the question for every administration is, what are we going to spend our time doing? It's possible that Commissioner Pai will decide that it's not his most important priority to repeal the net neutrality rules, but if he does, it may be not a high priority for the next administration to bring them back again. I think that the companies who act in this space act under the shadow of regulation. And so we have some hope that the companies have an economic interest as well as a political interest in keeping the internet the seedbed of innovation, the openness that we've all sort of enjoyed. And no one, industry or consumer groups, really wants the rules to keep going back and forth and back and forth.
There can be, as you point out, collective interests, but as you know, wearing your antitrust hat, restrictions on collective action, right? So I was struck by, maybe this is anachronistic, but in 2014, one observation was that just 30 companies controlled essentially 1/2 of all the primetime internet traffic. My guess is that that's probably even a smaller number now. So would consolidation in the industry represent threats to our nation's antitrust laws?
It remains to be seen under the Trump administration how much active antitrust enforcement there will be in these areas. But even under the Obama administration, there wasn't, outside of the merger context, much antitrust activity in the digital marketplace. But you've identified, I think, what's exactly the right problem. Today, in residential access networks, more than 60% of all traffic during prime time comes from Netflix and from YouTube. And
I'm doing my fair share.
I'm doing my fair share too.
Yeah, exactly.
Absolutely.
While there's funny cat videos out there and episodes of Homeland, it's not a commercial for Showtime, then I'm going to be working on it.
What unifies the two issues that you've identified, the broadband privacy rules and the net neutrality rules, was a view from the Obama FCC that internet service providers had a significant amount of market power. That is, we just don't have that many choices where we're going to get our high-speed internet service. And in fact, the Obama FCC on the broadband privacy rules was explicit that it needed to apply the rules to ISPs, but not to Google or to Facebook or to Amazon, because you had a choice. If you didn't like Google, you could use Bing. If you didn't like Facebook, you could use, I guess, Google. If you don't like Amazon, you can go to the store. But if that changes, if at the content and application layer we seem to get the same sort of concentration that we're having at the internet service provider level, then we should be concerned in a very similar way to apply policies at all of those layers.
So if we're not too far in the weeds already, let me get even deeper in the weeds by asking a question that strikes me as fascinating. Maybe you and I and a handful of listeners will be the only ones to think it so. And that is a potential lacuna in regulation. And so I refer back to a decision, a remarkable decision from the Ninth Circuit late last summer, in which the circuit court was asked to consider the scope of an agency we haven't yet talked about, which is the Federal Trade Commission, the FTC's authority under Section 5 to regulate, I think it was AT&T, right? And if I'm correct about this, I'm sure you'll correct me if I'm wrong, the holding was the FTC lacks this regulatory authority because even though the AT&T in this particular context was not acting as a common carrier, that it has the status of a common carrier. And so as a status of a common carrier, it's hands off from the FTC, which at the time is based on what I've read, is a remarkable ruling, leaves a significant regulatory hole.
It does leave a significant regulatory hole. And that is what the Ninth Circuit held. It has always been a difficult question of institutional design, whether the Federal Trade Commission should have authority over everything or whether there should be carve-outs when there are specialized agencies like the FCC. This issue is not just present in the case you're referring to, but it's present in the broadband privacy rules that you talked about. When the Federal Trade Commission, which has become our general purpose privacy regulator, faces the question of what to do about privacy on the internet, it faces this same problem of having a gap of being able to regulate ISPs.
So one of the things I read said the lacuna, the gap, is even greater in the following sense. They use the example of Google. So here's Google that would fall under, let's say that's being regulated for privacy concerns. Under the rubric of the Ninth Circuit holding, Google would not be able to be regulated because of, for example, Google's fiber broadnet internet access business. So in other words, it would have the activity of a common carrier. At the same time, the FCC would lack the authority to regulate it under Section 222 of the Communications Act, given its non-common carrier status. That may be too convoluted, but is that a real risk? I mean, if that's the risk, then neither agency would have the authority to regulate.
I think it's a risk from the way the Ninth Circuit wrote its opinion. I think at the end of the day, it can't be the case that the Federal Trade Commission has no ability to regulate Google's core privacy issues in its search business or its advertising business or with respect to Gmail, just because Google runs a few access networks that are not integrated in any way with its core search services. That just can't be the right result under the law. But you're right, that's one possible reading of the Ninth Circuit's.
Is there a third alternative in terms of a regulatory agency, or are they the only two games in town, leaving aside state regulation and other things that are probably unrealistic in this context?
The only third option on the table is to leave privacy regulation alone, right? So the direction that the repealer in Congress today is pointing is to take these issues from the FCC to the Federal Trade Commission, but there's also a very vigorous debate. Former Commissioner Josh Wright is most sort of attached to this debate of getting the FTC out of the business of regulating privacy simply because of the view those markets don't need regulation. Consumers can protect themselves through negotiating with the companies that might collect their information.
Let me shift to a little outside of the realm of privacy into the issue of cybersecurity. And now, although it's at least a couple years old, you recall the controversy, significant controversy over, I think it was Apple and the FBI, when the FBI was seeking to decrypt some of that data in order to give the FBI a much more significant weapon to combat ISIS and others. What's the status of that, both from the vantage point of law and regulation?
The status of that is quite open. The courts, for the most part, have come down on the side of the companies that have refused to provide information without proper legal process. Part of this has to do with Did the government need a warrant to get something? What did it need to establish the warrant? And part of it was, did they have an obligation to keep information or to maintain back doors? Interestingly, Trump was quite critical of Apple's decisions in the campaign, and he has promised, and his new national security staff has promised, that they're going to seek legislation requiring companies to keep back doors and to keep information so that there's a lot more ability for the national surveillance to get at this information when it's necessary.
So I want to ask you about the so-called Internet of Things. So I noticed there's a new device that Amazon sells, actually 3 devices to be more accurate, powered by something called Alexa, the Echo Dot, and the Tap. As I understand it, which is to say not very well, it's a portal or a device really into this remarkable development of the Internet of Things and raises interesting issues not only of technology, but how, if at all, we think about regulating it. Can you take us through that?
Well, personally, I think Alexa is an incredibly cool device. It's one of a number of devices. Google has one called Google Home. Apple is extending Siri to do this, where it essentially becomes an interface between you and the internet, but verbally. And so if I have an Alexa device in my room, I say, Alexa, put Tide on the shopping list. Or I can even say, Alexa, order Tide if I've set it up so that when I do that, it orders Tide from my Amazon account. Or I can have Alexa order me an Uber or play music. That's the #1 application for it right now. And all of these devices are trying to essentially create a smart home and a smart digital butler for me in all aspects of my life.
Again, naive question. What's to stop this device from falling into the wrong hands, which is to say, your Alexa falls into my hands, and I say, Alexa, drain my entire bank account, SPETA, now. Or you see what I'm getting at? I mean, not only the issues of privacy, but sort of the misuse of this.
Well, like all of these devices, we worry about whether they're hackable, right? Can I hack your device? Can you hack back into my device? But we don't even need to go that far. We have some examples of kids ordering things from Amazon by just saying, Alexa, order me a new dollhouse.
Let me say to our listeners, we're not endorsing that device, so any listeners who have kids.
And, Amazon obviously gave a refund when they found out that this happened, and they advised people to, protect their credit card with a verbal password, et cetera. But when you do those things, of course, the device becomes less convenient for you. So like all of the Internet of Things, the real issue for consumers is to be aware of what's happening with it. And on the privacy front, to come back to the issue of privacy, what information is being collected when you use these devices?
So maybe there's not a lot of daylight between you and Chairman Pai in the sense that these are matters not so much for regulation, but for a consumer responsibility and control?
I think that's right at the first level, which is I want to see these devices and these services deployed, see what they can do. I'm not anti-regulatory in the sense that I don't think we can ever reach conclusions about what are good practices and what are bad practices. Personally, I was very sympathetic with the FCC's regulation of privacy issues for internet service providers because they are in a position to capture what my political affiliation is, what my favorite sports team is, or to use something probably more important, if I'm searching for information on the internet about some disease that I have, they can capture all of that information, and that's a significant privacy issue to me.
So that provides the nexus between Internet of Things and also big data and the availability and the utilization of big data through technology that might become available.
Sure, and this is the big wave that's coming. Just this past couple of months, we've seen a few lawsuits and a Federal Trade Commission action against TV manufacturers. Vizio, Samsung, and LG all sell these smart TVs that you can watch Netflix or you can surf the web or do other things through the TV. And now the allegation is that those companies who created the TV have embedded in there a capture that sends back to a centralized server, and then they sell it to advertisers, what it is I'm watching, what it is I'm surfing, et cetera. And it's disclosed somewhere, but
in the fine print, as it were.
Exactly.
As you mentioned before, Alexa as a device competes with, or at least to some extent builds on, Google Home and the Google Assistant, Siri, maybe in an earlier iteration. So I guess I want to ask, what's unique about Alexa? Does Amazon have intellectual property in this device that makes it do very different things than those?
Well, I know a little bit more about Alexa because Northwestern law graduates are everywhere. And we have a Northwestern law grad who is leading the music team for the Alexa business model. And I talked to him a few weeks ago, and Amazon's advantages are a couple-fold in this area. First of which is they have a platform which is well-known. They've got this brand name. The second of which is they actually beat Google and Apple into the home. They have these devices out there being deployed. And then the third thing is they just have already built a great ecosystem where you can order things, you have applications, and you can do a lot more things today on Alexa than you can do on Google Home. As to intellectual property, Alexa faces the same sort of conflict that a lot of digital services do. On the one hand, their optimal view would be to keep their customers within their ecosystem as much as possible. On the other hand, they know what customers want to do is to access lots of different services over their platform. They want to access Uber, even though Amazon doesn't own Uber. They want to access...
Not now.
Not yet.
Yeah.
They want to access music from Spotify as well as music from Amazon Music. So Amazon has both a built-in business incentive to open their platform to other companies, but also an incentive to try to capture value as much as possible. And as you watch digital businesses make these sort of choices between open interfaces and closed interfaces, it's one of the most exciting issues out there right now.
Well, when I studied antitrust law in the Stone Ages, one of the ways that the law dealt with that is through some restrictions on tying. So I wonder whether or not that old model, right, of restricting ties in that respect applies to this new technology.
It sure does. And sort of the bridge between that was the famous Microsoft case involving browsers, right? And the question was, could you have the Windows operating system so integrated with the Internet Explorer browser that you couldn't have another browser on the system? Today, that same question is going on in Amazon. My sense from watching how Amazon and Google and Apple are developing these services is that they understand that the value of being able to reach out to third parties, being able to have this open ecosystem of apps is an incredibly valuable thing to consumers. Then the question becomes a matter of economics. Like on the Apple App Store, they take 30% of revenue. So the question is going to be, when you have a platform, what's the cut?
Well, you mentioned the three companies, right? And not a coincidence, right? Amazon, Google, and Apple. At least historically, legendarily, the last one you mentioned, Apple, has been the most reticent, right, to that open platform to generalize. But even they are coming around, you're suggesting.
Absolutely, they're coming around. They're coming around somewhat on the App Store. They're coming around on music. They're coming around on a number of other services. I think that's what consumers want.
Does that mean that I no longer will have to pay a quarter every time I use the expression, the Genius Bar?
I can't give you legal advice on that one.
Great, thanks. What do you think? So now let's get to 30,000 feet. What does the future hold for sort of avenues of the federal government to deal with these extraordinarily impactful and changing elements of technology?
I think it's quite challenging. And part of the challenge is that, as we say in the business, Congress always regulates by looking through the rearview mirror. But the pace of acceleration, as you've talked about with John McGinnis and with others on this show, the pace of innovation is just accelerating. And so we are confronting an era in which not just the techniques of innovation in the business sphere, but the techniques of innovation in response to possible regulation is just something that's very hard for general purpose legislatures to keep up with. And if they don't trust regulatory agencies to do it, then it's going to be very, very hard to do.
Do the courts fill an important vacuum, or are they even looking even more in a rearview mirror?
They're definitely looking more in a rearview mirror in the sense that matters only come to courts after there's been a problem, after a technology or a business model has been deployed and people have an objection to it or there's been a real harm to it. One possible solution is the drafting of general standards and leave it to a common law process. But again, in an era of accelerating regulation, you change the business model when you get sued and you simply move on to the next thing.
Are there other countries that are farther along than we are at dealing with these regulatory dilemmas, or is this a frustration that's shared universally?
I think it's a frustration that's shared universally. I mean, I think the fundamental trade-off is how much permission do you want to require before new technologies come to market? In the U.S., we've basically made the judgment we don't want a lot of regulation except in certain spheres of new technologies before they come to market. Surely when health is at issue, like with the Federal Food and Drug Administration, then we want there to be permission before new technologies. But in the internet and digital technologies, we've never wanted that. And so your trade-off is between losing your ability to regulate versus preserving it by stopping innovation in its tracks.
Interesting. We're going to need to devote an entire additional show in all of our respective spare time to talk about issues that I know you've been writing and thinking and teaching about in connection with the so-called sharing economy, Uber, Airbnb, and those greatest hits. So that's a teaser for a future show. But meanwhile, thank you for joining me, and that's our show for today. Thanks to Professor Jim Speta.
Thank you, Dan.
Thanks for listening. I'm Dan Rodriguez, signing off from the Northwestern Pritzker School of Law.
If you'd like more information about today's show, please visit law.northwestern.edu/planetlex or legaltalknetwork.com. Subscribe via iTunes and RSS. Find both Northwestern Pritzker School of Law and Legal Talk Network on Twitter, Facebook, and LinkedIn. Or download the free app from Legal Talk Network in Google Play and iTunes. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by, Northwestern University, Legal Talk Network, or their respective officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer.